Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler John Deaton, a prominent cryptocurrency supporter and lawyer, has highlighted why XRP is unable to reach $1 despite the coin receiving regulatory clarification in the SEC Ripple case. In the SEC Ripple litigation, U.S. District Judge Annalisa Torres announced the much-anticipated summary judgment ruling. The court deemed XRP a non-security in his judgment. However, as many projected, XRP did not see significant advances. On Binance, XR peaked around 93 cents on the day of the judgment before plummeting ever since. In general, CoinGecko data suggests that the currency jumped to roughly 85 cents a few days following the verdict. Several XRP supporters have voiced dissatisfaction with the coin's inability to reach $1 despite regulatory certainty. In a tweet today, Attorney Deaton said that many people would not have believed him if he told them that XRP would have regulatory certainty but would not reach $1. People would have been skeptical if he had also informed them that PayPal will establish a dollar-pegged stablecoin on the Ethereum network and that ETH would not rise. The pro-XRP lawyer said that Bitcoin, the world's biggest cryptocurrency by market cap, dominates the market. Like it or not, Bitcoin drives this market, emo, added Deaton. According to Deaton's tweet, Bitcoin influences the price fluctuations of other crypto assets. It is worth remembering that Bitcoin rose to about $31,500 on the day Judge Torres pronounced XRP a non-security. However, the top asset class fell below $30,200 the next day. Meanwhile, Deaton recently said that he never expected XRP to reach a new all-time high, ETH, before Bitcoin. Deaton believes that XRP will only reach a new high when Bitcoin leads a complete bull market. But I don't expect anything else to break its ETH until Bitcoin does, Deaton added. According to CoinGecko statistics, Bitcoin is down 57.45 from its all-time high of $69,044. In recent days, the top crypto asset has been trading at roughly $29,000. The lawsuit is the source of the outrage in XRP pump and dump activities. On this page, crypto lawyer John Deaton discussed the SEC's decision to appeal the XRP litigation. He says that the SEC intends to dispute portions of the court's ruling before the main case concludes. This might give the SEC an edge, but Deaton argues it doesn't guarantee victory. Deaton disclosed in his X post that the court would very likely consent to this early challenge. If this occurs, the judge may be able to better explain her ruling, making it more difficult to argue later. Deaton also believes that this is an opportunity for the court to address issues voiced by another judge. Deaton, for one, is waiting to hear what Ripple, the firm behind XRP, has to say before deciding what to do. He wants to ensure that his contribution offers something fresh and beneficial to the case. Deaton's observations demonstrate that the SEC's appeal might be a wise decision, but it is not sure to succeed. The procedure may strengthen the judge's ruling and aid to clarify certain legal issues. We'll have to wait and see what happens. According to the most recent developments, the court now intends to hold a jury trial in the second quarter of 2024. Given their sudden statement, the SEC may have missed the deadline to file an interlocutory appeal this week. Today marked the start of a new year of speculation, with XRP prices soaring by 66 cents before the market started, while other assets, such as ETH and Cardano, have struggled to reach new highs owing to their legal status. The upshot of the verdict is that any cryptocurrency may be a security based on the setting of the transaction, whether institutional or secondary market. While XRP may benefit from this as a cooling phase to maintain its market dominance, Gemini depicted XRP beating the U.S. Securities and Exchange Commission (SEC) in a fight in the video that accompanied the tweet. It also included a photograph of SEC Chairman Gary Gensler proclaiming Earth is a security. Interestingly, Gemini portrayed XRP moving to the moon in reaction to the SEC Chairman's alleged Earth is a securities postulation. Gemini's amusing video piqued the interest of the XRP community. Notably notable attorney Bill Morgan, who is known for his pro-XRP position. Morgan was ecstatic at the sarcastic portrayal of the U.S. agency and its chairman. Remember that Gemini co-founders Tyler and Cameron Winklevoss criticized the SEC's regulatory approach in their comments on the judgment, declaring XRP a non-security. The SEC sued Gemini in January for its troubled earned product. Meanwhile, Gemini stated in its official blog post on the listing that it has introduced support for the XRP ledger, pool blockchain. XRP is now traded on its Apifix mobile apps and online site as a result of this update. While traders may maintain their XRP on the exchange app, the exchange stated that XRP will be supported on its custody solution much later. Notable fiat currencies supported include USD, CAD, British pounds, Euro, Hong Kong dollar odd, and others. Gemini's current action places the exchange on the illustrious list of other US-based exchanges that have restored XRP service after the litigation victory. However, since a U.S. court ruled that XRP is not a security, the SEC has taken another effort to overturn the ruling. The Securities and Exchange Commission, SEC of the United States, U.S., has taken a critical step by finally filing an appeal in response to a significant court judgment issued in July. This important decision resulted from the SEC's legal battle with Ripple Labs, in which the court found that the sale of XRP to individual investors did not qualify as a security. This news was sent to Judge Annalisa Torres, the presiding judge in this case, just yesterday. Clearly, the SEC believes that the significance of her judgment requires a re-examination by an appeal court. According to the SEC filing, interlocutory review is warranted here. These two concerns include major legal matters on which there is tremendous room for disagreement, as seen by an intra-district division that is already formed. The SEC specifically requests that the court confirm the court's ruling that defendants is programmatic offers and sales to XRP, offers and sales to XRP. Purchasers through crypto asset trading platforms, as well as Ripple's other distributions in compensation for labor and services, did not comprise the offer or sale of securities under the Securities Act. Judge Annalisa had methodically articulated her goals within the confines of the U.S. Southern District Court. These preparations included a trial that would go into unknown territory, addressing matters that had not been addressed in the earlier petitions for judgment. This trial has been tentatively scheduled to take place in the second quarter of 2024. The SEC has established a time frame for the arduous task ahead in its official proposal. A prominent point of attention is Ripple's impending response, which is due on August 16, 2023, only 1 week after the aforementioned letter was filed. The SEC offers a precise series of actions to meticulously coordinate the ensuing phases. On August 18, an opening brief explaining the reasons for the appeal will be submitted. This compels Ripple to draft a response within 2 weeks. The SEC, poised at the helm of this legal dance, is ready to give a rejoinder within a week, depending on the judge's approval of this planned legal pass to Troy. Crucially, the scope of the U.S. SEC's appeal is well defined. In contrast to a larger challenge to XRP's designation as a security, the agency's attention is on a more nuanced canvas. The appeal focuses on the consequences of the token's programmatic and individual sales, with the government declining to argue the wider categorization judgment. Because the SEC does not yet have the right to appeal, they are requesting permission to file a interlocutory appeal. Next Tuesday, Ripple will submit its answer with the court.